Court is on the record in a civil action entitled In Re Failure to Obey Subpoena, Dakota Mullen, case number 25 MIS 10. The court issued an order to show cause on June 4th, 2025. The order basically reads that pursuant to Rule 17G of the Ohio Rules of Criminal Procedure, the failure by any person without adequate excuse to obey a subpoena served upon him or her may be deemed a contempt of the court or officer issuing the...
All right, quick legal reset before this goes any further. This isn't a criminal trial yet, this is a contempt proceeding. When a court says show cause, that's judge speak for, explain yourself, and it better be good. Missing a subpoena isn't paperwork drama. It's a direct challenge to the court's authority. And judges, they take that very personally.
On May 29th, 2025, Dakota Mullen was personally served with a subpoena in City of Conneaut versus Ann Headley, case number 25 CRB 105, ordering her to appear on June 4th, 2025 at 1:00 p.m. at Conneaut Municipal Court. The court did attach to its order a copy of that service return from the court bailiff indicating that service had been perfected personally upon Ms. Mullen. Ms. Mullen failed to appear on June 4th, 2025 pursuant to the court order subpoena. I then issued that order ordering Ms. Mullen to appear today, June 25th at 1:30 p.m. We're starting a little early, to show cause why she should not be held in and punished for contempt of this court for refusing to comply with the court order to appear on June 4th, 2025 in the Headley case. Ms. Mullen is present. She is not represented by counsel. Also present is Law Director John Lewis. Pursuant to Section 2705.02 of the Ohio Revised Code, specifically subsection C, a failure to obey a subpoena duly served or a refusal to be sworn or answer as a witness.
This part matters. Under Ohio law, contempt isn't just about punishment, it's about compliance. The judge has to hold a hearing, but once service is proven, the burden quietly shifts to the person who didn't show up. Translation, convince me this wasn't your fault. Spoiler alert, that's harder than it sounds.
An act of contempt pursuant to Section 2705.05, a hearing is required in all contempt proceedings. At that hearing, the court shall investigate the charge and hear any answer or testimony that the accused, in this case Ms. Mullen, makes or offers. If the accused is found guilty, the court may impose any of the following penalties. For a first offense, which this would be, a fine of not more than $250, a definite term of imprisonment not more than 30 days in jail, or both. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You are Dakota Mullen.
Yes.
Ms. Mullen, you were served personally with a subpoena by the court bailiff on May 29th, 2025 in the case entitled City of Conneaut versus Ann Headley. Is that correct?
Yes.
You were ordered by the subpoena to appear on June 4th, 2025 at 1:00 p.m. Do you recall that?
Honestly, with all the subpoenas I've gotten over the past month and a half, I do not recall.
I don't want to hear that, Ms. Mullen.
That reaction right there? That's the moment the temperature in the courtroom changes. Saying, I don't recall, after being personally served is one of the least effective defenses you can offer. Judges hear excuses all day, but this one just landed flat. What would you have said here?
I don't want to hear it.
I understand.
She was the victim in the Headley case, right? Or alleged victim?
Yes, sir.
Poor excuse, Ms. Mullen. So I want to know why you weren't here that day.
I cannot,
Tell me the truth.
I truly cannot recall the day, but I'm sure it was probably a day where there was Todd's case, the day before, or the day after, or 2 days before, 2 days after, and I just mixed it up. I don't know. That's all I have to say.
I don't recall, Mr. Lewis, did Ms. Headley's case got dismissed, right, because of Ms. Mullen's failure to participate or appear?
No, Ms. Headley's case we're having a hearing on it today, Your Honor.
Oh,
Yeah,
maybe that's why I scheduled it
it's
today.
it's scheduled for a final pretrial today.
Okay.
Yeah,
What time is it scheduled?
1:30, Your Honor.
Well, Ms. Mullen, you're not going anywhere because I'm going to defer. I'm not going to take action on on the contempt until I'm assured from Mr. Lewis that you are actively cooperating with him. What your decision about how to proceed on the Headley case is between you and him. I'm not telling you you have to proceed in a certain way or not.
This is actually a pivotal turn. Instead of hammering her immediately, the judge presses pause and gives her a chance to cooperate. That's judicial discretion in action, and it's a gift. But gifts in court come with strings attached. Miss one more step, and this whole thing collapses fast.
But I am directing you to cooperate, and that's what a subpoena is for. You are to cooperate. You are to be here when you're supposed to be here. I will address the contempt proceeding here shortly, and we'll see what happens. So you can go back into the area where victims are normally located until Mr. Lewis needs you, okay? Okay. The court is back on the record in City County versus Ann Headley, as well as in re failure to obey subpoena of Dakota Mullen, 25 MIS 10. I took a recess on this case to allow Ms. Headley's case to go forward. Ms. Mullen was issued an order to show cause as to why she should not be held in contempt of the court for failing to obey a court order to appear on June 4th, 2025 in the Headley case. Before I proceed, I'm going to ask Mr. Lewis. Mr. Lewis, did you find Ms. Mullen's participation to be cooperative?
Yes, Your Honor. Today's participation, she was cooperative, yes.
Okay. What's your position with respect to holding her in contempt of court because she forgot or didn't? She really didn't have a reason other than too much going on. I'm not sure.
Your Honor, I agree with the court's decision to go forward with this miscellaneous charge, and I think that she should be held in contempt of court. She did not give a reasonable excuse other than she just forgot or was confused for not appearing. Thank you.
Thank you. Okay, Ms. Mullen, you are still under oath. What would you like to say in response?
I'm not sure. I just the traffic court and all of these, and it's no excuses. I have no excuse.
Are you high?
No, I'm just really upset because hearing my mom's payments and then my fines and my previous fines and fines money in it and everything like that, it's just hard to, without me being able to find a job and no other income other than return, it's a lot to think about right now.
Well, we've had some experiences with you, Ms. Mullen, over the past month or two, and you've testified recently in another case. I can't remember which case it was, but it seems like you've You've appeared before this court quite often here in the last few months in different cases, and I just don't like your appearance. I am going to hold you in contempt of court for failing to appear on June 4th, 2025. I'm going to suspend 30 days of jail. I'm not going to impose a fine. I will waive court costs, but I am going to order today that you submit to a urine drug screen, and I am going to, once I see the results of that urine drug screen, call you back into the courtroom, and then we'll decide to complete the sentence with respect.
Here comes the ruling, and notice the balance. 30 days in jail suspended, no fine, costs waived. That's mercy. But then comes the curveball, a drug screen. Judges don't order those casually. This tells us the court sees a pattern, not just a missed court date. Do you think this was about punishment or prevention?
To probation. Okay, so you're going to submit to a urine drug screen today. Anything further, Mr. Lewis?
No, Your Honor. Thank you.
Ms. Mullen, there will be someone who will assist you in that respect. Thank you. The court is back on the record in failure to obey subpoena in Dakota Mullen, case number 25 MIS 10. For the record, the court has been recording these past few hearings involving Ms. Mullen under the "and" heavily bookmark. So I made a mistake on that, but we are back in the courtroom to continue the sentence. Ms. Mullen is in court without counsel. Also present was Law Director John Lewis. When I found you in contempt of court, Ms. Mullen, I imposed a sentence of 30 days jail, suspended. I waived a fine. And before I completed the sentence, I ordered that you undergo a urine drug screen. The results did match what my suspicions were. You tested positive for ecstasy, benzos, amphetamines, methamphetamines.
And there it is, the reveal that explains everything before it. Once substances enter the picture, the court's focus shifts from punishment to control and treatment. Probation, restrictions, assessments. This isn't just consequences anymore, it's the system stepping in to manage risk. The real question now is, will this intervention help, or just delay the inevitable?
And marijuana. Are you currently receiving the treatment services of any substance abuse or mental health agency?
I was working with Signature Health after I got out of the hospital in December. I did not follow through, but I would like to go back to them if I get recommended from them.
Anything further, Mr. Lewis?
No, Your Honor. I suspected that you did, and you were correct.
Okay, I will, as I said, I'm going to place her on supervised probation with this court. I'm going to order that she submit to a comprehensive diagnostic assessment at Signature Health and successfully comply with any recommended course of treatment. She's ordered to remain drug and alcohol free. She's not to possess or consume any alcoholic beverage or drug or abuse. And she's not to go into, that includes as well pseudoephedrine products, and she's not to go into any bar or liquor establishment for the term of her supervised probation, which will be 2 years. She will have to pay the probation fee and costs, and I will give her until December 31st to pay all costs in this case. I'm advising Ms. Mullen of her right to appeal, of her right to appeal without cost, of her right to have counsel appointed on appeal without cost, of her right to have documents provided her necessary to file an appeal without cost, and of her right to have a notice of appeal timely filed on her behalf. Okay, Ms. Mullen, over the next 2 years, you're going to be on probation with us. You're going to be meeting with the probation officer periodically, and he's going to be monitoring your compliance with my sentence. If over the course of the next 2 years you're found to have violated in any way the terms of your probation and sentence, in this case, you do face up to a maximum 30 days in jail. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already done. So do you understand the consequences you face if you're found to have violated your probation?
Yes, sir, I do.
Yes, go ahead.
I was planning on going back to dancing at clubs, which I don't know if they serve alcohol or not. Am I allowed to?
Yeah, well, here's the way this court operates, Ms. Mullen. First off, a bar is a bar is a bar, and so when I order you to stay out of a bar, that means to stay out. Now, if you really want to make that request to me, I want to see a letter from the bar, or from, I should say, not a bar, I want to see the letter from your prospective employer offering you a job on their letterhead, and I want you to make a written request for me that you would like to be able to go to work there. See, we don't operate on speculation, I may work, or I'm going, it's not speculation. I want to see an offer, and then I'll consider it. And I'm telling you, depending on the place that I'm thinking you're asking me to allow you, it's probably going to be a no. But perhaps you might want to look at other more productive employment that's respectful of you and your recovery. Anything else, Ms. Mullen? Okay, thank you. This matter is concluded.